The reality is that when two people even are together, father and mother, husband and wife, the family is intact, you have to be a nut to think that there's no conflict that ever exists. That's part of, if we are saying the exact same thing, what value is being added? I mean, we want a male perspective, we want a female perspective. And what that means is that there will be conflict because our brains think differently, we have different experiences. One's a woman, one's a man, excluding the gender ideology of today. So there is going to naturally, the natural state to me is that there is going to be some conflict because of different perspectives, different sexes and everything else. So, I mean, it's very interesting that you're talking about this. And what you'd be saying then, if you want to take this to the next logical step, would be to say that, and even in marriage, only one parent should be a super parent.
Well, I think even in marriage, would we place the same restrictions on a married couple in terms of disagreements between parents in a married situation about school or types of discipline or types of friends? Because there are state statutes that say that there should not be any discrimination based on marital status. Right. That children should have the same rights in married as unmarried situations. That issues of civil rights issues related to gender and religion and marital status should have no play in deciding who is the primary custodial parent. Right. So, but this common mantra that you'll see in the report that's highly focused on the issue of co-parenting is the common mantra and intertwined of co-parenting among the courts, co-parenting among the family attorneys, which is advertised to the legislatures. So it's almost like a symbiotic relationship, almost like an intertwined relationship. And who does it benefit? Well, if the child custody evaluator is focused on that, which is rather collaborative with the judiciary and the family law attorneys, and by emphasizing conflict and eliminating the possibility of equalized parenting for the child, who benefits?
The industry.
Well, I think that, yes. We already know federal incentives to the states based on Title 4D. And we already know that if Alissa Sherry focuses and emphasizes and misadvertises the issue of parental conflict, it keeps her in business with the family attorneys because she gives them what she wants, she gives them what they want. It's the common mantra. It's collaborative with the common mantra of the judiciary. So if you have a state actor, whether it's an employee of the state, an employee of a municipality, it could be judges, could be any other employee, and they're taking action in order to wrongfully deprive an individual or group of individuals of the ability to carry out functions such as associations, speech, or deprive them of their parent-child relationship, so to speak, or monies or properties. And if you have private entities, that it can be determined that their relationship with the government state actor is such that they're in one way or another collaborating, induced,
almost have a
symbiotic or intertwined relationship. They're also vulnerable to pursuit, to legal pursuit in federal court. So I guess the question
I hear what you're saying.
So I guess the question is Alissa Sherry vulnerable? Is she working in collaboration, symbiosis, intertwined with state actors to deprive parents of their children, so based upon fraudulent reports?
Yeah, that's
in collaboration with different attorneys.
That's very, very interesting. So basically, then, are you looking for the deprivation of rights under the color of law, more or less? I think there's another statute that's more specific.
Yeah, there's very different statutes, but the basic premise is deprivation of rights under the color of law. Yeah. And there's the 242, 245, 1983. 1443, 1446. Those are slightly different, the last two.
And one of the things that I've seen with this is that in a situation like yours, in order to maintain the mantra, as you've talked about, they would consider you to be a nuisance, somebody who's angry, somebody who's bitter, even though they're depriving you, what you're talking about, of some of these fundamental rights, your right to parent your child, your money, your property, your ability for free speech. They look at you as being a nuisance, troublesome, and other things, and they want to label you. But one thing that I found was very interesting, and this was, my youngest daughter, 2 years old, was in the room. She, 2 years old, right? And all of a sudden, from another room, I hear, "That's not fair! That's not fair!" And I thought, how does a 2-year-old know the concept of fairness and justice and injustice?
That's a very good point, because I think what kids are learning that are in this situation, even with our child, our son, he's seeing that things aren't fair, right off the bat.
Yeah.
And so what are we teaching our children?
Right.
Basically, we're teaching them how not to be fair in this aspect.
Yeah.
And they're going to gain insight over time and wonder, why are they being restricted from one parent versus another, or more restricted from one parent versus another.
After they have traumatized and broken them, though.
Yeah, and there's a lot of trauma that goes on. So I think the main jest that's occurring in this situation is you have a child custody evaluator that's acting in a kind of intertwined symbiotic relationship, who now is not neutral, because obviously she's carried out actions and acted as an advocate for one party against another. She's created a report with a false narrative that's contradictory to objective testing. This report has been published. The objective testing has been published, and it's on the public record. And she's making recommendations that cause trauma to the child. In addition, she's working in collaboration with Marshall Thompson to deprive a parent of a child and deprive the child of a parent based upon false allegations, false information, which is basically fraudulent. I think she's been getting away with it for so long because probably she's been smoozing the courts for so long and smoozing the judges, and they don't know better, and they're not supposed to know better because they consider the expert with this whole field of knowledge. But when you really look at the report and her theoretical basis are just cut and paste excerpts from different authors that don't even apply.
Yeah.